Hello again. Chapter 11 it is. The theme of Chapter 11 is the complexities and challenges of liberalism in practice. In other words, we have it in theory, it sounds good in theory, but what are some of the issues that we have when it's out there? And we're going to be looking specifically at Canada and the United States. All right, just a quick review of the spectrums. Once again, this is the economic spectrum ranging from collectivism to the left to individualism to the right. Communism, like I said, to the left, centrally planned economies. Laissez-faire capitalism to the right. And then anywhere in the middle is a mixture of those economic systems. This is the political spectrum. Once again, the extreme rejection of liberalism are on the ends, whether it's a left-wing dictatorship or a right-wing dictatorship, and then democracies fit in the middle. Here's a power spectrum ranging from complete total power that a statist regime has over its people to where there's absolutely no power, or another word, anarchy. Okay, some more. We've looked at this earlier this semester, where certain historical figures fit on this spectrum, combined political and economic spectrum. You can see Stalin and Hitler are high on the control area, whereas people like Friedman and Gandhi are more towards libertarian. Okay, this is the one that's probably the one that you looked at quite a bit this semester, and at one point this semester have already memorized. All right, so there are three main themes in chapter 11. We're going to cover the first one today, and I will cover um, the other two tomorrow, or I'll do two today and then one tomorrow, but we won't do all of them today. Section 1 is why and to what extent do some liberal democratic governments promote individual and collective rights? You're going to be learning that in our own country, for example, we promote both of these rights, but you'll see how sometimes they come in conflict with each other. Whereas the United States, at least throughout most of its history, they have promoted individual rights. Section 2, how do liberal democracies balance the common good with the need to respect said individual rights? And so it just kind of adds on to the first section. What is the balance? You're going to see in our own country that it seems like the collective good or the common good a lot of times will supersede um, individual rights. And then section 3 is why do liberal democratic governments choose ultimately to reject the principles of liberalism in some cases? So the term illiberalism will come up. Why are there times, kind of thinking back to chapter 12, what are some ideologies and conditions that not only could threaten liberalism but ultimately destroy it? Right now we're living through this pandemic, the COVID-19. This would be an example of how some of our traditional freedoms have been taken away from us for the sake of security. All right, so the first section, picture of Prime Minister Trudeau signing the Charter of Rights and Freedoms and the Constitution, 1982, with Queen Elizabeth. Why and to what extent do some liberal democratic governments promote individual and collective rights? Why and to what extent do some democratic governments, I'm just repeating myself here. All right, so when we look at rights as a people, in our own country, we kind of break those rights up into individual rights. We have individual identity, aspects of individual identity, but we also have a collective identity. And of those collectives that we belong to that we learned about in Social 10, there are 5 collective groups that are protected under the Canadian Charter of Rights and Freedoms, the so called collective rights. I'm sure you've seen this. I showed this to you when you're in grade 9, but collective rights are for the Aboriginal people, the First Nations, the Métis, and the Inuit. And those collective rights are protected in a combination of historic treaties and modern treaties. They're all protected under the 1982 Constitution, whereas the First Nations, their collective rights have been protected in a number of treaties that have gone back hundreds of years. Whereas the Métis and the Inuit have been protected only from more modern type of treaties. The other 2 groups that have collective rights in our country are the Anglophones or the English speaking Canadians and the Francophones, the French speaking people. Both individual and collective rights in a democracy are usually promoted, entrenched, which means placed in there so that it's almost impossible to get out without some sort of constitutional amendment, and protected by specific legislation within specific documents. Examples would be in the United States, you have the Bill of Rights, you have the US Constitution, the subsequent amendments. Many of those were created in the late 1700s. And so you would see a lot of reflection of classical liberal individual principles. Whereas our own Canadian Constitution, the Charter of Rights and Freedoms, and the Quebec Charter are more modern liberal in nature. So you're going to see more representation of the protection of collectives, of groups, because modern liberal is, in a way, more collective in nature. So, like I said, you should be able to see the relationships between the American Bill of Rights, the US Constitution, perhaps how that influenced a little bit of the BNA Act. Remember, the BNA Act came, almost 80 years later, and so it would reflect more modern liberal principles. And then certainly with the Charter of Rights and Freedoms that came up in the 1980s, it would certainly reflect more modern liberal principles. I think there's a question in your assignment that deals with comparing the Quebec Charter of Rights and Freedoms or the Quebec Charter of Human Rights and Freedoms to the Canadian Charter of Rights and Freedoms. Yes, the Quebec Charter came first, the Canadian Charter came after. Ultimately, the Canadian Charter supersedes the aspects of things that go on in Quebec, except for, and I'll explain this notwithstanding clause a little bit later. But like I said, the Canadian Charter of Rights and Freedoms came into fruition. We patriated our Constitution. We brought it back home. The Constitution originally was passed in London back in 1866, 1867. It had never been patriated until the 1980s. And so it was brought back. It became our document. And that was kind of the final step towards sovereignty that we attained, basically 30 some years ago. This document functions to guarantee and protect both individual rights for all of us as individuals and collective rights for the aforementioned specific groups in society. So, some of the examples of the Canadian Charter of Rights and Freedoms, specifically the individual rights, we have fundamental freedoms: religion, belief, thought, opinion, expression, assembly. And that doesn't just carry on for Canadian citizens, but for people in Canada in general. Now, for Canadian citizens, we have democratic rights. We have the right to vote, right to run for office, join a political party, run in elections, etc. We have mobility rights. So if you don't like Alberta, you can go. If you don't like Nunavut, you can go. You can find work in other provinces. You can enter and leave. Well, see, this wouldn't be an example of how some of those rights have been suppressed for the sake of security. You have legal rights. You are presumed innocent. You should be given a fair trial. Okay, you shouldn't be subject to wrongful imprisonment. Um, you have your Miranda rights, or I don't know if they call them that in Canada, but you have your rights when you're arrested, etc. So you all have rights before and under the law. You are treated equally, regardless of your background. Equality rights cannot be discriminated against because of your race, your ethnicity, your color, your religion, sex, orientation, etc. All right, getting back to Quebec specifically, in Quebec's um, collective rights, this is a quote from, I'm not even going to try to pronounce this guy, Brzezinski. He says promotion and protection of minority cultures are reasonable and worthy goals. However, when do laws designed to protect and assist one group restrict the free choices of others? In Preponderance of Blood, essayist Tody Kondax compares Quebec's language laws with those of South Africa and the Soviet Union. All right, well, obviously, Quebec has language laws, whether it's Bill 101 and some of the subsequent ones that were created. The purpose behind those language laws is to promote the Quebecois culture, to keep it viable, to keep it alive. And yes, the collective rights of the Quebecois, time and time again, have superseded the individual rights of individual people that live in Quebec. All right, so let's just read in this. It says unrestricted access to publicly funded educational institutions without threat or fear of discrimination is a universally recognized civil right. According to a statute, French is the official language of education in Quebec. Because of federal constitutional requirements that guarantee the minority Anglophone population right to education in the English language, two different categories of civil rights for individuals residing in the province of Quebec have been created. One, individuals who are classified solely on the basis of who their parents are and what the parents' classification is, as having the civil right to attend only French publicly funded schools. Two, individuals who are classified solely on the basis of who their parents are and what their parents' classification is, as having the civil right to choose either French or English publicly funded schools. So, in other words, if you come from a French background, you have to go to a French speaking school. If you come from an English speaking background, you have the choice. If you are an immigrant that comes into the province, you have to go to a French speaking school. All right. So there's another part of the charter that I want to talk about. One of the things, when they were trying to get all the provinces to agree to the Constitution, the charter. By the way, Quebec never did sign the Constitution, but you know, and then I'm not a lawyer, but they still invoke clauses. Yeah, whatever. It's a slippery slope. But there is a clause within the charter. It's called the notwithstanding clause, section 33. Essentially, it's like your veto power. Okay, you know how the UN has with the Security Council, the 5 permanent members, one of them, they all have the power of the veto. The President of the United States, when a bill is passed, he can veto it from becoming a law. Well, within our charter, there's a veto power of sections within the Charter Rights and Freedoms. Okay, and that's called the notwithstanding clause. Go ahead and look it up if you want some a little bit more explanation of that. Basically, a province can supersede or go against aspects of the charter for a period of 5 years. The problem with it is that they can just, you know, when the 5 years is up, they can just, we're going to go another 5 years and we're going to go another 5 years. But the thinking is they have 5 years to get a law that actually fits within the charter. The reason why it was signed is that provinces would not agree to the Charter Rights and Freedoms and the Constitution unless this out was included. They wanted some sort of out. So, when Quebec passes a law that counters bilingualism, they can invoke the notwithstanding clause. I believe Alberta has threatened to invoke the notwithstanding clause from time to time. I probably should know a little bit more about that. It's not often used, but it is in our Constitution. All right, the last little clip here is that Bill 101, the so-called language law that was passed prior to the Constitution, has been amended on a couple of occasions, and I think the latest is that Bill 178. And so that would be an example of how they changed 101 to a point where it was acceptable under the Charter Rights and Freedoms, under equality rights. All right, so here it is a little bit more technical. It says Parliament or the legislature of a province may expressly declare in an act of Parliament or of the legislature, as the case may be, that the act or provision thereof shall operate, notwithstanding a provision included in Section 2 or Section 7 to 15. I know they write this like lawyers speak, and it's very difficult to understand. But, anyways, an act or provision of an act in respect of which a declaration made under this section is in effect shall have such operation as it would have but for the provision of this charter referred to in the declaration. Holy prepositional phrase. Holy cow. Anyways, a declaration made under subsection 1 shall cease to have effect 5 years after it comes into force or on such earlier date as may be specified in the declaration. Parliament or the legislature of a province may reenact, and this is the kicker here, a declaration made under subsection 1. So in other words, 5 years passes, they still haven't got the crap together, they can just pass another legislation and the clock just starts ticking again for another 5 years. And so they basically can go against the charter, at least in some of these areas, for an indefinite period of time. Subsection 3 applies in respect of the reenactment made under subsection 4. Okay. All right, there are other issues as far as collective rights in our country. Our history of bilingualism, the battle between francophone rights in other provinces. Bilingualism, say, for example, the whole issue that occurred with the Manitoba schools question, in our own province, the growth of francophone schools or French immersion schools, etc. So you can look at that. All those bills, 101, 178, 86, promote and protect French in Quebec. Okay. Outside of Quebec, bilingualism is a federal institution. Okay. Anyways, this just gives you an overview of when these legislations were passed. As you can see, 101 was passed prior to the Charter Rights and Freedoms, whereas the other two were passed after the charter. And so they had to come in and follow the charter. In our own province, we've had a history of language rights. The Alberta School Act in 1968 designates the use of French a language of instruction 50% of daily school time. Okay, is extended to 80% in 1976, applied though to publicly funded schools. After the Charter Rights and Freedoms in 1982, under Section 23, instruction provided in minority language if 1. First language learned was French or English where they live, or one has received primarily education in English or French and the language is of the minority where one lives. So in other words, if a bunch of people live in Alberta and they're francophone and they want to be educated in French, they have that right under the Charter Rights and Freedoms. Okay. If there's a population of people, say in central Alberta, say we want a francophone school, you can have it. Okay. In Ontario, if there's enough people that speak French, same type of thing. And then in theory, if there's enough English speaking people in, say, Quebec, they have the right to be taught in English according to the Charter Rights and Freedoms. Here's a timeline of some of these acts. Okay, once again, the Supreme Court had to make rulings so that the laws passed in Quebec would fit within the Constitution. Okay, an example here would be in 1988 with commercial signs. under Bill 101, English signs were forbidden, but they came up with some sort of compromise that basically said if the English equivalent in the sign was smaller, significantly smaller than the Francophone part of the sign, then it would be allowed. Okay. And then the aforementioned education rights. If you are Anglo, you can send your kid to an English speaking school. If you're Francophone, you don't have a choice. Obviously, Aboriginal rights have collective rights within the Charter of Rights and Freedoms. The various different sections of the Charter, for example, Section 25, the Charter of Rights and Freedoms cannot be used to take away treaty rights. So, any rights that they already have from their historic treaties, from the Proclamation Act back in the 1700s, the BNA Act, the Indian Act, whatever act. Okay, those cannot be taken away from the charter. Okay. Section 26, rights granted cannot be used to deny other rights that exist in Canada. So it's kind of an add-on to 25 there. And then Section 35, okay, existing treaty and Aboriginal rights affirmed or supported. Aboriginals include, so they define what is an Aboriginal, First Nations, Inuit, Métis. It includes rights via land claims or those future acquired, and also granted equality to males and females. So, for example, prior to the charter, if a male First Nations man married a female that was not First Nations, he retained his rights. But if a female First Nations woman married a non First Nations man, she lost her treaty rights. And so, under the chart, obviously, that doesn't fit under equality rights. And so that was changed. There's some other issues. We have specific land claims, um, comprehensive land claims. I mean, we learn about lots of specific land claims in 10 and 20. Oka would be an example of a specific land claim. Okay, and these land claim issues are ongoing. Okay, also, what rights do First Nations, Inuit, Métis have that is different than other Canadians, specifically in hunting and fishing? All right. Once again, the big picture kind of question, do the collective rights of a group of people outweigh the individual rights of individual Canadians? And over and over and over again, you're going to see that the collective rights seem to trump the individual rights of Canadians. And then a couple other issues here is, once again, these land claims are specific and comprehensive, are ongoing, and the whole timeline of them being settled, is unclear. Okay. And then the whole issue of, what is a nation and what is sovereignty and how much sovereignty and freedom do respective First Nations groups have in comparison to Canada. Very nebulous, concept. But feel free to read in your textbook. All right. So I think that's going to be it for today. I will cover um, the other two themes tomorrow. And section 2 will be, how do liberal democracies balance perceived common good with the need to respect individual rights? And then section 3 is, why do liberal democratic governments choose to ultimately reject? Okay, and that will be as big or probably even bigger than section 1. So I will cover sections 2 and 3 in my lesson tomorrow. But until then, take care, and I'll see you when I see you.